Your lawyer can quit your case and the judge will let them, even if your trial date is already set, even if you think, I've already paid enough. Most people don't find this out until it's too late. I'm Matthew Harris, a board-certified family law attorney in Texas. Let me explain exactly how attorney withdrawal works, what your rights are, and why ignoring your legal bill is one of the fastest ways to lose control of your case. Here's the assumption that most clients make. My lawyer can't just abandon me. They can't just walk away. But they can ask the judge for permission to withdraw, and non-payment is the most common reason that requests get approved. Withdrawal does not mean your lawyer storms out or rage quits. It means this: your attorney files a motion to withdraw. You're given notice. The judge decides whether continued representation is reasonable. Yes, that's right. If you've stopped paying your legal fees, then your attorney is required to file a written motion with the court and inform the judge, the other side, and the general public about your financial situation. And yes, the other side will smell blood in the water and will likely try to take advantage of the situation. But more on that in a minute. If you've stopped paying, stopped responding, or ignored repeated billing notices, the judge usually sees the problem clearly, and that's when the order gets signed. Clients often say, but I paid a retainer. Yes, but that retainer is not a lifetime subscription. Retainers are advanced deposits, not promises of unlimited work. Your attorney charged against that retainer at their hourly rate, and it will eventually be exhausted. When the retainer is exhausted, continued representation depends on continued payment. No payment means no obligation to keep working. This is the part people underestimate. Once your lawyer is officially out, deadlines do not stop. Hearings still happen. Orders still get signed. Mistakes still count. The court does not pause your case so you can figure things out. You are now pro se, whether you wanted to be or not. If you're in a custody case, your ex may try to set hearings while you're scrambling to find a new attorney. If you're in a criminal case, those plea offers may suddenly dry up. And, just FYI, judges hold pro se parties to the same procedural standards as lawyers. Even if your attorney desires to withdraw, you are still entitled to notice of the withdrawal, your client file, any unearned fees, time to retain new counsel when reasonable. None of those rights fix missed deadlines or bad outcomes that are caused by delay. My practice is to send the client a link by the end of the day with their entire case file so they can begin to represent themselves without delay. I've seen lawyers literally print off the entire file, even emails, just to spite their client. Unfortunately, losing your attorney just before trial doesn't guarantee a continuance. If your attorney gave you several warnings, look on your invoices, then it is a lot harder to argue to the court that their withdrawal is a surprise to you and that you need more time. Here's the irony no one tells you. Stopping payment often makes the case more expensive, not less. Why? Because new lawyers see withdrawal as a red flag. That means higher risk, tighter timelines, many hours of cleanup or catch-up, which usually means a larger retainer paid up front and less flexibility. Therefore, non-payment doesn't save money, it burns leverage. This part is important. Most lawyers don't want to withdraw. Withdrawal slows cases down, creates risk, and generates zero goodwill. But lawyers also cannot work for free, front litigation costs indefinitely, or ethically continue representation when the relationship breaks down. Unfortunately, lawyers have significant monthly overhead that they have to pay whether you pay your invoices or not. There are bar dues, licensing fees, malpractice insurance, legal research subscriptions, rent, so on and so forth. For every hour they put toward your case without being paid, that's also an hour they cannot put towards another case who will pay or have paid their fees. Here's the bottom line. Your lawyer quitting your case isn't personal, it's procedural. And if you ignore the problem long enough, the case doesn't disappear, your protection does. If you're struggling, talk to your lawyer before the motion is filed. Because once the judge signs that order, you're on your own whether you're ready or not. If your attorney just warns you they're about to withdraw, or if your attorney has already withdrawn, then perhaps these pro se courtroom tips or pro se testimony tips will help you keep your head above water. From the bottom of my heart, I wish you nothing but success in your case, and I'll see you in the next video.